What are the three common mistakes that a judge will make in a Social Security claims denial? Now, you need to understand that if your claim is denied, you'll have 60 days to file an appeal with the Appeals Council. And what we find is that there are three common mistakes that judges can make. First is in credibility determinations. Many times a judge will deny a claim on the basis that your testimony is incredible. And in reaching that conclusion, the ALJ will review your medical records and your report of symptoms and functionality, and even the forms that you have filled out. They're going to compare what you said or what someone put on the third-party function report and seize on any differences. They'll also cherry pick your testimony looking for discrepancies, and depending on where you live, the judge may also be required to give a detailed reasoning why they've concluded that you are not credible. Number two are medical determinations. The opinion of your physician should be given great weight by a judge over the opinions of the state doctors who reviewed your medical records. That's often not the case. And I think it's a great reason for challenging your denial if your medical records are strong. Number three, vocational determinations. The ALJ has to decide at step 4 whether you can return to your past work, and at step 5 whether you can do other work in the national economy. And during the course of the hearing, the vocational evaluator, who will be testifying, is going to be closely questioned by the judge based on hypotheticals about your physical and mental restrictions and limitations. The judge formulates that hypothetical based on the medical records in your file, the opinions of the Social Security consulting doctors, and the opinions of your doctors as expressed in residual functional capacity forms that you should be getting filled out. Now, what I find is that the judge will often make mistakes in formulating the hypothetical, and that results in a wrong answer from the VE. But more importantly these days, what Social Security is doing is having the vocational evaluator testify about the job numbers that they have determined. So once they've determined the occupation, they testify about the applicable job numbers. And in my view, this has become a testimony of fiction, because vocational evaluators are not statisticians, and what they're trying to do is to take DOT codes and translate them into occupation numbers. I won't go into a lot of detail, but I am finding that the hearings are becoming quite contentious as we cross-examine vocational evaluators to get to the basis of the numbers. And the reality is they don't really have a good basis for their numbers. So I'm going to be predicting that we're going to be seeing a lot more appeals going to the Appeals Council and even federal court until Social Security gets over this crazy methodology that they're having VEs, vocational evaluators, use to testify about job numbers. If your Social Security claim has been denied, you only have 60 days in which to file an appeal. And if it's based on a vocational denial based on job numbers, give us a ring at 727-894-3188 for a complimentary consultation. We'll look at your decision, we'll listen to the hearing, and we'll give you an honest answer as to whether we think we can help you. But don't wait till the last minute, because we aren't going to be looking at it if you call us on the 50th day. It just isn't going to work, because these appeals take a lot of time and effort. We've got to look at the decision, and we've got to listen to the testimony so that we can formulate the legal basis for a successful challenge on a vocational denial. 727-894-3188 for a complimentary consultation.